Welcome to the latest edition of Akin's Speaking Sustainability podcast. I'm your host, Chad Smith, a consultant with the firm specializing in environmental, social, and governance, or ESG, matters, as well as corporate law matters. As corporate governance practitioners, we regularly monitor legal developments that may affect directors of U.S. corporations, particularly developments out of Delaware, which remains the country's most important source of corporate law. Two cases arising from the same fact pattern, Marchand versus Barnhill, and Discover Property and Casualty Insurances versus Bluebell Creameries USA, highlight the need for directors to understand both the contours of their duties under Delaware law, as well as the scope of insurance coverage that may, or importantly, may not be available in relation to claims implicating those duties. During this podcast, we are going to explore the current state of Delaware law in relation to directors' duties, limitations on the protections of the business judgment rule, when directors may be personally liable in relation to breach of loyalty claims, the availability or not of indemnification and insurance protections, and areas that may be of particular concern for directors in the current legal and regulatory environment. We also will take a look at risk management and oversight strategies that companies and directors can employ to guard against potential liability in these areas and more broadly. My guest today is Jim Deeken. Jim is an Akin partner who represents a wide range of private fund managers and fund formation activities and in investments into a wide range of investment funds. He is an adjunct lecturer at SMU's Dedman School of Law and writes and speaks extensively on a wide range of issues. Most recently, Jim authored Bluebell Meltdown Serves Up a Double Dip of Danger for Directors, which was published recently in the Securities Regulation Law Journal. Jim, welcome to the podcast.
Thank you. Great to speak with you today and talk about what is going on.
So for the benefit of our listeners, I'd like to just have you recap, sort of the basic elements of Delaware fiduciary laws applied to members of a Delaware corporation's board of directors.
Sure. So these are kind of the things that people learned in law school, but many years ago, and they seem to change over time. So the first duty that a director owes is what is called the duty of care. The second duty is the duty of loyalty. And what duty of care means is that a director needs to exercise the duties with requisite care that an ordinary, careful, and prudent person would use in similar circumstances, using all information reasonably available. So a lot of times people think that that's the duty to pay attention to what's going on, to use informed judgment, to make decisions that have a reasonable basis. The other duty is the duty of loyalty. What the duty of loyalty is it requires in its inception an obligation to stay away from self-dealing. And also, importantly, an obligation to act in good faith. And good faith is somewhat vaguely defined. It's been fleshed out in case law to mean things that somebody wouldn't necessarily think of when they hear the term good faith. So a director may not put their own financial or self-interest above the interest of the corporation. And they can also not engage in conduct that would be injurious to the corporation at hand. Closely related to that, as part of the duty of loyalty, is a good faith component. Good faith component means that a director avoids subjective bad faith motivated by an actual intent to harm a corporation. However, even though that sounds ominous and people are like, well, I would never do that, what also can mean is that a director breached its obligation to act in good faith by conspicuously disregarding a duty to act. So it doesn't necessarily require affirmative malevolent intent. And I think that's the trap that some people fall into and some people are not extremely aware of.
So if I'm a director and I'm, discharging my duties on a corporate board, there's protections available both in sort of the company's organizing documents as well as under Delaware law itself. And one of those protections is the benefit of the business judgment rule. Can you spend a minute sort of talking about what that means?
Sure. And this is where directors get their comfort from. It's what we learned in law school, where basically a court will not second guess a business judgment that's made by directors. So basically, as long as they made a decision, even if it turns out to be unwise, that they made it on an informed basis and a rational belief that it was in the best interest of the stockholders, they generally will not have liability for that because that's a business judgment. However, it is important to realize and appreciate that the business judgment rule only applies to the duty of care. It only provides protection for directors with respect to one of the two fundamental duties that they have. It does not provide protection for a breach of the duty of loyalty. And remember, included in that is the obligation to act in good faith, which could have some subjective elements to it.
So
So it's not complete protection.
yeah, I mean, that is, I think, just one of the critical points that we want to underscore here as we get through some of these topics. In your article, you write about directors being concerned about claims alleging, as you were just talking about, breaches of the duty of loyalty, not just because the protections of the business judgment rule may not be available, but also because the benefits of indemnification provisions, for example, or relief under insurance coverage also may not be available under those in relation to those claims. Can you just explain and why directors need to be mindful of those particular risks?
Sure. So a lot of times directors are indemnified by the corporation. They might think, okay, well, maybe if the business judgment rule doesn't apply, I still have indemnification, right? And the answer is, well, you sort of do if you act in good faith in a manner that you reasonably believe not to be opposed to the best interest of the corporation. So the indemnification generally only applies to the duty of care. If somebody violates the duty of loyalty, they generally are not indemnified by that, and they can't be indemnified for that generally under the statute. So that's a big hole in indemnification. Secondly, insurance policies, and a lot of people don't realize this, the mistake I think a lot of people make is they ask, is there insurance? And the corporation might say yes. And a lot of people might stop the inquiry there. Remember though, insurance is really a contract to provide indemnification subject to certain terms and provisions and conditions. And there are carve-outs, there are limitations, there are a lot of pitfalls in these insurance policies. A lot of them provide exclusions for breach of the duty of loyalty or for acting in bad faith. So you might find that there's no insurance coverage for a violation of the breach of duty of loyalty, as well as no indemnification.
Yeah. So before we get to the two cases that sort of underlie your article, I'd like to sort of spend a moment and ask you to talk about the so-called Caremark line of cases that come out of Delaware and sort of what that line of case law stands for.
Sure. So what Caremark does is it takes the duty of loyalty, the obligation to act in good faith, and it says as part of the obligation to act in good faith, directors have oversight liability. And they violate the duty to act in good faith if they fail to implement reporting and information systems and controls to monitor risks to the corporation. Or, equally important, having implemented such controls, they fail to monitor them and oversee them appropriately. So that's how somebody could become entrapped in a liability. There may be a risk that a director never heard of before, for example, but they should have been aware of, and they should have had systems in place to monitor. And even though they may have consciously done nothing wrong in their mind, they could still not be viewed as acting in bad faith.
Let's turn to Marchand and its contours. And one of the statements in your article that I found really compelling was the quote, the case accents how a board needs to make sure that it has procedures for monitoring areas that pose risks for the corporation. Maybe you could take our listeners through the fact pattern and some of the issues that were involved there.
So Marchand was the Bluebell case, where Bluebell had a case of listeria, deadly bacteria. Some people ate the ice cream, they died, and shareholders brought a derivative suit against the board. And they brought it under the Caremark theory for breach of the duty of loyalty. And they argued that the directors violated that duty. And one of the things they argued was that the board did not have in place, this is the allegations, they're subject to being proven in court, but they didn't have in place procedures to monitor food safety. And the court went through and looked at minutes, and they said there weren't sufficient reports on this, there wasn't sufficient oversight. Therefore, the plaintiffs had made a credible, at least to withstand summary judgment, allegation that the directors had acted in bad faith and not put in place these oversight provisions.
Yeah, I think you touch on the fact that the court, looked at minutes. It also looked at sort of contemporaneous notes and just sort of found that there was really just no effort on the part of the board to really monitor these particular risks. And then one of the things that we'll touch on in a bit here is just the importance of making sure that you're creating a record relative to a board's oversight of these risks and issues. Obviously, we're also focused on director liability, but I would just pause to note that a recent case, I think it was last year out of Delaware, it was the In Ray McDonald's case, extended the duty of oversight to corporate officers as well. So that's just something that folks listening should be mindful of.
Yeah, very much so.
So I guess as you think about Bluebell and this line of cases, maybe could you spend a moment talking about sort of we talked a bit about the insurance issue. So I guess one of the things that I would like to focus on is like, it's one thing to say that, as you pointed out, we do have D&O coverage, but what are some of the things that need to be sort of diligenced as a director thinks about joining a board relative to that insurance coverage? It's not
So,
enough just to have coverage. You need to have the right kinds of
right
coverage.
coverage. So I think certainly we be within the realm of a director to say, I need to see the insurance policy when I have somebody review it. I want to understand what the claims made nature of it is. I want to see what the exceptions are. I want to see what the caps are. I want to see what your policy is in place for monitoring claims, making sure that they're reported on time. Those are some of the basic questions that I would ask in terms of insurance. The other thing I would want to do if I'm joining a board is I would like to talk to the GC's office and talk to them about what are the major risks that this corporation faces in terms of product liability, in terms of violation of law, in terms of loss of customers, and what do you do to monitor that so that the board is aware of what's going on, and what type of reporting systems you have up to the board level so that the board is reasonably able to monitor these. And not only reasonably able to monitor them, but reasonably able to act upon them if the information is in fact passed along to the board. And one of the things you could do is ask to see those procedures and how they're in place, and also look at board minutes to see, okay, is the board actually discussing these things?
Yeah, how are we capturing that oversight?
Right, exactly.
Yeah. And one of the things that I regularly advise clients is to also make sure that you're looking at how the board committees are structured relative to these reporting obligations as well, because one of the sort of key areas of scrutiny of late is making sure that board committees are actually sort of tasked with ensuring that some of these oversight structures are in place as well, and sort of making sure that that sort of through line of risk oversight exists within the corporation. There are a handful of areas that seem to be at the forefront in terms of potential sources of liability for directors these days: labor, health and safety, environmental issues. Can you maybe spend a moment sort of helping us think through sort of how to address those particular issues? Are there any sort of areas of particular concern in those areas that we should have our listeners be mindful of?
Right, and it depends on the industry. So, for example, company that's in oil and gas, for example, will have safety issues. A company that is involved in healthcare will have cybersecurity issues, data protection issues. And what's interesting, Chad, is if we just think back 10 years ago about the number of regulations that a corporation had to comply with, it was much less than what it is today. Yeah. And what's happened in the current regulatory environment is there are so many regulations with so many fines, so many enforcement actions. There's so many pitfalls that a corporation could step into that could have a material adverse economic effect on it. There's so many traps, so many things to watch that I really think a corporation with this legal department needs to go through and figure out what are all the areas of potential liability? What are all the things we could get fined for? What are all the things we could get sued for in a class action in the current regulatory environment? And it changes, right? You have to keep doing this over and over again, and having in place a comprehensive reporting system to identify those. The other thing, Chad, that we're seeing is 10 years ago, you seldom heard the term ESG, right?
Right.
Now you hear it a lot. And so a lot of this regulatory environment is being driven by environmental, social, and governance concerns. You're having two effects. One, you're having more laws and regulations passed, but also there is a lot of public pressure on corporations to act in what people view as a socially responsible manner. So in addition to maximizing profits, there's a lot of people who are arguing that something called stakeholder capitalism, that corporations are supposed to do other things. They're supposed to consider the environment, workers, those type of issues. The issue they have is there's no law that requires a corporation to do that. Law might require a corporation to do something else, maximize profits. However, what the ESG advocates can look at and say, okay, even though there's no law to engage in stakeholder capitalism, you had a law to breach of your duty of loyalty required you to follow the law, and you violated the law about labor, you violated the law about the environment, you violated the law about whatever this other ESG regulation was. You created liability for the company, therefore you're liable. So in a way, the Caremark doctrine, when you can combine it with ESG, puts pressure on directors to indirectly at least consider ESG matters in a manner that they didn't historically have to consider.
Yeah, I think that's exactly right. And, it's particularly here in the US, I mean, we're just seeing a lot of political pushback relative to ESG. We've had a number of states enact sort of what we would describe as anti-ESG statutes that, preclude state agencies, for example, of considering ESG factors when making or investing state public funds or making procurement decisions. And then you have other jurisdictions, obviously, that are encouraging or requiring the consideration of the ESG factors as they sort of make those state fund investments. And then sort of layered to your point on top of that is just a regulatory environment that, we've had a lot of rulemaking initiatives at the federal level via the SEC, recent climate disclosure rule. Last year's cybersecurity rules went into effect. They have indicated that they're not done, although, given that we're gearing up for an election, who knows what we'll actually see between now and November. But you also have the complexities that you have major asset managers, as you know, and some of the proxy advisory firms really insisting that boards of directors demonstrate through disclosures or elsewhere how they approach oversight of ESG issues. So I think it's a really critical point that you make in terms of that being a potential area of liability for directors.
And here's one way, not the exclusive way, but one way a director can navigate that path. Certainly a director could say, I have a duty to maximize profits. I don't have a duty necessarily to forego profits to pursue an environmental objective or a labor objective. However, I have an interest in making sure that we comply with labor laws, environmental laws, and that we avoid environmental liability because that affects profitability, right? If there's an environmental accident, we have to shut down the plant. That impacts profitability. If we're making products and we get sued, company gets sued for some sort of products liability issue, that affects profits. So in a way, I think there's one way to look at ESG and say ESG is not necessarily opposed to profit maximization, because there's a certain area where there's an overlap between maximizing profits and pursuing ESG initiatives. I think that's where a board needs to look at what are our legal obligations, how do we do this, how do we do it in a way that's consistent with our duty to stockholders, but also in a way that's consistent with our duty of loyalty.
Yeah, and I think, the other sort of corollary there is also being mindful of, making sure that as a corporation makes sort of public commitments in relation to an environmental issue or human capital management or whatever, that they're also sort of mindful of what we would refer to as greenwashing risks and making sure that what we're saying we're doing is actually what we're doing. And so that's just another area where directors just need to be mindful of the potential liability traps there. We're going to close out by talking about some sort of practical steps boards and can take relative to these issues. But one of the things that I thought we should maybe ask you, given your area of expertise in relation to investment funds and fund managers, is if I'm a portfolio company and if we have a portfolio company and I've been asked to serve on a board, are there any sort of particular areas of concern in that scenario that the folks should be mindful of?
I think you have to look at what are the insurance policies, what are the risks. I think you have to realize that even if you're on a board as a representative of a fund, you have fiduciary duties to the corporation as a whole. And I think that's easy to forget. And it's important to remember that because you have to comply with the duty of loyalty and the duty of care, while at the same time, wearing your fund investor hat. And hopefully as an investor in a company, as being a representative investor, you'll be aligned in wanting to comply with the duty of loyalty and duty of care. So they're not necessarily opposed to each other, but I think it put accented importance on it. And just when you join a board, remember, it's not just acting for the fund that you represent. You are assuming when you become a director a lot of obligations and a lot of potential liabilities and a lot of responsibilities. And that may sound daunting, but it can be mitigated by having the right legal education, the right advisors who help you advise as to what those duties are and how to comply with them. Not only how to comply with them, but as you know, Chad, how to document that you complied with them as well.
Exactly right. That's sort of the key piece that sometimes gets lost in these conversations. And that does lead us to sort of the last sort of set of questions here, which is, we've touched on the importance of record keeping good minutes, robust minutes. I mean, and when we talk about minutes, we're not talking about documenting the debate itself, right? We're talking about documenting the fact that the debate occurred and what the result was reached by the board of directors. We talked about, reviewing the insurance coverage and talking with the GC's office around sort of particular issues, legal and regulatory risks for the company in question. Maybe you could spend just a moment talking through some of the other practical steps that boards of directors can take to sort of mitigate the risks in these areas. And obviously, we're not looking to give out legal advice here, but I do think that there are some practical things that boards can take a look at doing.
Sure. I think it's just a question of how is it monitoring risks? Does it have special committees in place to monitor different risks? How is the information that the committees get sent around to the entire board? How is it documented? Does the company have a whistleblower system or some sort of reporting system where information will get funneled up effectively? And also, to what degree, it's not a commercial for our services, of course, but to what degree have they gone through with reputable counsel specialized in the area that poses risk to them? And to what extent have they obtained legal advice on how to put in place proper monitoring, reporting, and acting upon information? And a lot of people might say, oh, that's more legal expense. But as you and I know, heck of a lot cheaper to do it right on the front end than it is to pay government fines on the back end, or to have your business shut down, or face costly shareholder litigation later on.
Absolutely. One of the other things that occurs to me is, the boards and the board committees, we regularly advise folks, you need to evaluate these monitoring systems from time to time periodically, so that as the market, as your industry changes, as legal developments and regulatory developments occur, you're keeping pace with those changes. And so I think that periodic evaluation is also something that folks shouldn't forget.
And one thing I'll hit upon, Chad, that just comes up a lot is public companies with their public reporting. A lot of people view that as, oh, well, it's their public reporting. What law firm will do it the cheapest, right? And as you mentioned too, with greenwashing, the pitfalls you can run into with just securities law reporting are enormous. For example, the SEC, if you're saying in your public statements that you're best in class when it comes to environmental items, or you always prioritize safety first, unless you really do that, you're creating a lot of securities liability. Certainly, there's nothing wrong with saying that we value safety, but you never want to say superlatives were the best, right? Because there's always somebody better. And so it's just really taking a careful view and careful eye to reading those disclosures, 10Ks and 10Qs. A lot of people might think, oh, that's boring stuff. That's for the lawyers. Well, it is for the lawyers, but it's for the directors too. Right. And if you're a director, I think it's important to ask discerning questions about, we are saying this. What do we do? How do we document it? And if we say, for example, that before we do something, we check something, is that somebody in marketing department who wrote that, who is disconnected from the operations group that actually does it, and the operations group doesn't necessarily know they need to do it? And you might say, certainly that would never be the case, but we do know there are a lot of SEC enforcement actions where it is the case, where sometimes people's rhetoric is put out there and it's not put in place. So if you're a director and you're reading these things, it's important to say, okay, we said A, B, C, and D. We're going to do that. And how do we document we're doing it? How do the people that are supposed to be doing it know they're supposed to be doing it? So I really think this increasingly, when it comes to director oversight, is not an area where people need to be cutting corners on.
I think that's absolutely right. And, the scenarios that you just described in terms of a director really digging into sort of how are we doing what we say we're doing and creating that record, that ties back to how we started, which, if you do those things, if you exercise and properly discharge your duties relative to serving on a board, you're going to have the protections available to you under Delaware law and various contractual arrangements and what have you. So. Well, Jim, thanks. That is all the time we have today. I really appreciate you taking the time to talk with us today.
Sure, thank you. It's two key words: be aware and act.
Absolutely. Thanks a lot.
All right, thank you.
On Air with Akin is presented by Akin and cannot be copied or rebroadcast without consent. The information provided is intended for a general audience and is not legal advice or a substitute for the advice of competent counsel. Prior results do not guarantee a similar outcome. The content reflects the personal views and opinions of the participants. No attorney-client relationship is being created by this podcast, and all rights are reserved.